For many years, I've told people and I've repeated the opinion that if you do have to go with a court-appointed attorney or a public defender, it can be okay, it's not a problem. And the reason I've thought that is I've known a lot of good public defenders and a lot of good court-appointed attorneys throughout the years. But I've changed my opinion, and I now believe that if it's at all possible for you to get together the money, get together the funds, call your family, and invest in your defense, you really should do that, and I'm going to explain why in this video. Now, it's important, and I want to say right off the bat that this is not a reflection on the abilities of a court-appointed lawyer or a public defender. My opinions on their abilities haven't changed, and like I said earlier, I have known, and I still know, a lot of very good lawyers who are public defenders and court-appointed attorneys. But the truth is, they're overworked, they're underpaid, and they don't have the time they need to devote to every single case. And I do want to share one story of a recent client I had who was facing a probation revocation years ago. We're talking almost 10 years ago now. He had a court-appointed attorney, and that court-appointed attorney signed him up to a quick plea deal. And when I looked at the facts of the case, it didn't look like the kind of case that I would have accepted a plea deal on. And the reason why is that the state's case rested on a single witness who was extremely unreliable and had a long criminal history. Now, typically in those cases, I'm able to get them dismissed. Sometimes my clients require to do things like classes to get them dismissed, but I don't have them sign up for a plea deal, especially one that requires an assault family violence finding, because that finding stays with you the rest of your life. But what my client told me was that his court-appointed attorney at the time was handling a murder trial in another jurisdiction and told him, "I don't have time to take your case to trial." So she advised him to accept the quick plea. Now, what you might be thinking, and what he was probably thinking at the time, was no big deal, right? It's probation. But that's really not the right way to think about it, because here he was sitting in custody because he was being revoked on that probation. But not only that, the assault family violence finding is following him the rest of his life. There is no way to get that off of his record. So at the end of the day, even though it would have been difficult for him 10 years ago to pull that money together and invest in his defense, had he done so, he would have saved himself at least a week in custody, plus a lifetime of that family violence finding and conviction that will follow him wherever he goes. There are public defenders, there are court-appointed attorneys out there who do give that a time and attention they need, but at the end of the day, it's a gamble that you're going to get one of those who's going to fight for you, as opposed to an attorney who's going to tell you, "I'm handling a trial, I don't have time to deal with your case." Just don't take that gamble. Your life is far too important, and the consequences last far too long for you to gamble with those kind of consequences. ATX Legal offers payment plans. We accept credit cards. If you are facing charges in Travis, Hayes, or Williamson, give us a call for a free consultation. We'll discuss your case, and you can decide how to proceed from there.